Hi, good afternoon, everyone. This is Rajiv S. Khanna for immigration.com, the losses of Rajiv S. Khanna PC. This is our bi-weekly telephone call, community conference call, every other Thursday at 12:30. Remember, as the announcement said when you logged in, this call does not create an attorney-client relationship, and we are trying our best to guide the community. This is not a substitute for one-on-one consultation. Um, while I'm talking, I'm also monitoring my Twitter feed, and my Twitter handle is immigration calm without the dot. So if you have any comments that need addressing right then, go ahead and tweet me. You can also see the Twitter feed on immigration.com, our website, on the right hand side, and also on the forums on the right hand side panel. Okay. So today is September 3rd, 2015. Let's go ahead and proceed forward with this call. Let me begin with the first question. From Ram Shankar, Ram says, my I-94 expiration date for both H1 and H4 is August 15 with the previous employer. New employer applied for H1 only until September 2015. About a year back and it was approved. Excuse me for a second. Okay. Now new employer extended from September 3rd to October 13. October 2016, I'm sorry. Along with this, H4 extension was also requested. It was filed with the USCIS before the H1 expired, which was August 10, 2015. Both have been approved with the I-94 dates from September 3rd, 2015. So, but what has happened is there's a gap of a few days from August 11 through September 2000, for September 2nd. So less than a month gap. This is not a problem at all, Ram. This kind of a situation crops up quite frequently. As long as the extension was applied for before the current status expired, the fact that the ultimate approval created some gap between expiration of the prior status and beginning of the new status is not an issue. So don't worry. If you have any questions that are follow up on this, you can press *5. No new questions, follow up question on this issue, *5. All right. I didn't think there would be. It's a simple enough matter. Next question is Vijay Mar 820, Vijay Mar 82. How do we find if your employer filed your PERM on EB2 or EB3? There is no section on I-797 or application form showing EB3 EB category. Well, depends upon what you are looking at. If you are looking at PERM, there is nothing there that will obviously shout out to you whether this is an EB2 or EB3 filing, because the shape of the application is the same. However, the normal requirements for an EB2 application are either a master's degree or a master's degree plus 3 years experience and bachelor's with 5, or bachelor's with 5 years experience. These are the normal 3 ways of stating the PERM requirements. But don't try to make that judgment yourself. It is a complicated issue, and really a lawyer should look at the PERM application and decide whether it is likely to go through under EB2 or EB3. Okay? If you're on the phone, press *5. Any follow-up questions, press *5. *5 on your phone. Okay? Vijay Mar also asked, if I have a Balka case pending from 2012, is there a timeline? It's usually about 3.5 years, I think. If you go to immigration.com, I'm looking at our own website. Easiest way is I go to the footer. In common topics, there is a, right here, if you look at the bottom, processing times and status checks. I click here, and let's look at, if you look at the left-hand side, PERM, I think it's in here. This is all PERM. Balka time should be here. Status checks, administrative appeals. Let's see. We used to have Balka times. I'll tell them to post them. I don't see them. National Visa Center PERM processing. I'll tell them to post that. It's about 3.5 years normally. You'll see a new column being created here. I'll put something here. And once again, I remind people who have logged in a little late, I'm also monitoring my Twitter feed. It's Immigration Calm. That's my handle. Immigration Calm, my ID on Twitter. I'm also monitoring that. Okay, so Balka is about 3.5 years. I will have them update a section of the website. You'll have better information. Let me just make a note of that. I'll make sure to remind somebody to put that section up. Okay. Vijay, try not to post separate questions because typically they stop after 24 questions. So all these questions, they just count and it ends up, these are simple yes and no answers. So maybe it's taking away from other people who could have asked and put their issues forward. Okay, last question from Vijay is that my employer doesn't provide my approved I-140 or the receipt number. How should I obtain a copy of the receipt number? Well, the only thing I can think of, sir, is that you apply for under Freedom of Information Act with the USCIS. Many times they'll give you a copy of a lot of your paperwork. So it's called a Freedom of Information Act / Privacy Act request. I forgot the name of the form. I think it's G something 634 or something like that. It should be there on the US. It is there on the USCIS website. Doesn't cost you any money. Ask for all your immigration related documents. They should be able to give you, and often they do give you copies of the I-140 approval. Banyan Tree says there's a friend who's facing a situation on his H1B and may have to leave the country. His I-94 expires March 2016. 6-year I-797 expires March 18th. His PERM is planned to be filed by the end of September 15th. Can he work after 28th March? Actually, he can't work after 18th March because typically the 10-day additional is just to leave USA, not to work here. So he cannot work after 18 March, and he definitely cannot work based upon the PERM, because if the PERM is filed in September of 2015, his eligibility for H1 extension will begin either in September 2016 or when PERM is approved and I-140 is approved. One of two. Okay. If you're on the phone, press *5. I can take follow-ups on this. *5. Okay. Let's go on to the next one. Perry Putter wants to know, brother-in-law is a US citizen, but he's living in India working for a US company. Can he sponsor his parents while he's living in India? The answer is yes. But the problem is, by the time they get their green card interview, he should be able to prove that he is in the process of moving back to USA. For example, already rented a place or bought a place or admitted his children to school, because the affidavit of support requires that the person who's sponsoring should be domiciled in the United States. Okay, so he can do it. And as far as co-sponsorship is concerned, only green card holders or US citizens can act as a co-sponsor on Form I-864, affidavit of support. Would he be able to get insurance under Obamacare? I have no idea. not an expert in insurance issues. You may want to check with an insurance agent or a benefits expert of some kind. If you're on the phone, press star 5. I can take follow-ups on your questions. Okay, there's one question from somebody. Let's go to yeah. There's a lot of noise. I unmuted you, Florida. I unmuted you, but there's a lot of noise coming from your side. I don't know what the problem is. I'll try it one more time. Okay.
Excuse me, sir.
Yeah, go ahead.
I have a question. I'm now this F1.
Okay, sorry. Not doing any new questions. No new questions. At the end, please. No new questions. And you need to do something about your phone line. I can barely hear you. There's so much noise. No new questions, guys. No new questions. Only questions that I'm discussing right now. Prem Shiva Kumar Bankala has a problem. He had a post-completion OPT expiry date, and there's a problem with the service. The extension was denied because it was applied 120 days prior to the post-completion. Prem, the problem here is this. As far as the driver's license is concerned, I'm not sure anybody can do anything about it. You should definitely speak, it doesn't hurt, to speak with your local legislator. So if you are living in New Jersey, and let's say you are living in, I don't know, Orange County, you would talk with somebody local and ask them, typically your legislator, member of the New Jersey Legislative Council, whatever that body is called. Like in India, we have MLAs. Talk to a local MLA, not a congressman, which is federal, but an MLA kind of person here. See if they can help you. But they do enforce very strictly the rule on the STEM applications. I am not sure I can make any good suggestions. This is an issue that is not covered by regulations. This is an issue of processes and procedures. And really, the only thing you can do is follow the instructions of the DSO, because the designated school official is somebody who can call service people and who can talk with USCIS directly and try to get you the information that they can. There isn't much I have to add to this, but I do know that they will enforce the rules very, very mathematically, because these days that they count and the days that they use are definitely jurisdictional in nature. They are taken very, very seriously. If you're on the phone, press star 5. Star 5, Prem, if you're here. Okay, let's go on to the next question. You got your conditional residence approved. You already paid the immigrant fee. Okay. So you are already coming close to your second anniversary. Can I enter after my second anniversary so I can get my visa category changed to immediate relative? So basically what you're trying to do is you are trying to avoid the situation where, hi, somebody just raised their hand from Virginia. You press star 5. I'm not taking any new questions. We'll do that at the end of the call. Put your hand down, press star 5 again, please. If you have a follow-up question, we'll take it now, but no new questions. We'll come to it towards the end, okay? So, first of all, I do not know what is the best way to handle this is. You've got your conditional residence approval, but that means you'll have to wait 2 years to remove condition. Very close to getting your second year anniversary. If you look at the regulations, if I remember correctly, regulations say if you enter USA after your second anniversary, you should get your permanent green card, not a conditional green card. So I do not know. Exactly how this will play out, I'll have to look into it. I do not know the answer off the top of my head. What I would recommend you do is this: have your spouse contact their congressman, okay, and have them pose the same question of the USCIS and the CBP, Customs and Border Protection. Okay, so ask them. I don't know about the fees triggers and all. Look, I don't keep track of fees, etc. My job as a lawyer has been confined now for many years to the legal side of things. Other people in the office take care of all the details. So you, like I said, my suggestion to you would be to have your spouse contact your congressman and whoever is the federal congressman in the area, whether it's a member of the House of Representatives or senator. They will find out all this information free for you, and they tend to be pretty efficient. Okay, so do that. If you are on the phone, press star 5. If you are on the phone, press star 5 if you have a follow-up question. All right, let's get to you. 1 second. Go ahead, please. I can hear you.
Yeah, good afternoon, Rajiv ji.
Ji, good afternoon.
In case I am granted CR1 at the port of entry and I entered before after 9th of November, can I get it changed by filing an I-90?
Like I said, I am not aware of, or I've never run into this situation before, so I've really never looked at it. Offhand, I don't know the answer, and rather than pay a lawyer to find out the answer, have your spouse contact the congressman. They can give you the information free.
And how does the spouse contact through an attorney?
No. You know how in India, if you have a problem, you can contact your MLA and they'll help you out. It's kind of the same thing here. Your MLA or your member of parliament. What I'm saying is, it's free of charge. She finds out who her congressman or woman is. She calls them up, tells them, I have a problem. Can you give me the solution? They'll find out all the information for you. Okay, and they're pretty quick about it. All right.
It could be a senator as well, Rajiv, right?
Yeah, senator, which is like in India we have Rajya Sabha, here we have Senate, or it can be Lok Sabha, which is House of Representatives here. Either one. Okay.
Okay. Mostly I have gone through the online blogs and forums. Most of the attorneys say that it is at the port of entry where decides whether I get an IR1 or a CR1.
I think you should confirm it through the congressman's office. Unless, look, all the information from any private site is worth nothing unless you get it either from a government website or from a congressman or from a consultation with a lawyer. So generically, what anybody says, I don't really care about that. The information is not, in my mind, not reliable until it comes through number 1, like I said, a government website, number 2, a congressman, and number 3, in a personal consultation. Okay?
Sorry, sir, can you repeat the last part of the statement?
Sir, I would not rely upon that information if I were you. I would not depend upon it. Okay? Good luck.
Okay, thank you.
You're welcome. Next is, let's see. Flower Girl says, I'm applying for a health insurance for my new immigrant father under Obamacare. If I just put his individual income, he'll be eligible for government subsidies. Okay, again, this is an issue that concerns something called public charge. So the law says, once you get your green card through a family-based petition, the person who sponsored you is responsible for you for the next 5 years or until you complete certain number of, I forget how many quarters of work in the United States, or you become a US citizen, whichever is the first one to be achieved. Okay. So the question is, what kind of benefits jeopardize the money or the financial payback from the sponsor? What kind of benefits? And the answer is, normally any means tested benefits. So while I haven't looked at what the exact provision of the law that you're going under is, generally speaking, if a benefit depends upon the income of an individual, it would trigger or it can trigger the sponsor's liability, and it can make the immigrant deportable. It has both consequences. So, not knowing exactly which benefit we are talking about, nor have I researched that particular issue, it's difficult to make a definitive call. But I can certainly make you aware of the general issues that if it's a means tested benefit, depending upon the income of the individual, um, it can trigger both deportation as well as um, the sponsor's obligation to pay back the government for the benefit received. Okay? If you're on the phone, star 5, Flower Girl, press star 5 if you're on the phone. Star 5. All right. Neil says, I'm on my second H1B extension, valid till 2018. First one is approved for 2 years. I have started my green card process. Can I file I-140 and 45 concurrently using my wife's country of birth, Panama? Absolutely. Absolutely. You can and you should, because if your spouse is born in a country other than India, it is definitely going to be helpful for you, Neil. So file under cross-chargeability. If you are on the phone, press star 5, Neil. If you're on the phone, press star 5. We can talk if you have other questions. All right. Let's go on to the next one. Vittorio says, I'm an Italian citizen, currently under H4 in USA. Interesting business opportunity, would like to apply for E1 visa. There's an exclusive contract with a Spanish private school in order to organize in the US a series of 12 workshops for about 1,000 students every year. Okay. So the question is this considered to be substantial trade? Do not know. Do not know. I have not run into this particular situation, Vittorio. Do me a favor. Just copy your question and email it to me. I'm interested in the answer myself. Just copy this and email it to me. I will have this looked at and we'll let you know. Okay. So I'm only going to examine the issue of substantial trade. As to what nationality the new company will get, the nationality of the company for immigration law could be different, for corporate law could be different. Generally speaking, as I understand it, privately held companies are considered to be the nationality or domiciles of the country of incorporation. So if 3 citizens of Spain and Italy and France form a corporation, in USA it's a privately held corporation, I am pretty sure for most purposes that would be considered to be an American corporation. If, on the other hand, it is a publicly traded corporation, at least for US immigration purposes, we look at the majority stock holdership. So, or controlling. So, for example, if the company is 90% in the public domain and 10% owned by one family or one individual, and that's the largest holding, and those individuals are Italian citizens, if I remember correctly, that company will be considered to be an Italian company. Okay. We may want to talk about this a little bit more. I'll give you a free consultation for 15 minutes, Vittorio. Send me an email. Okay. I want to look at the substantial trade issue, and then as I'm looking that up, I will make sure I get all your questions answered. As far as organizing and corporation is concerned, even as a student, you can form a corporation. You just can't work. Okay? So until the e-visa comes through, you will not be able to work. Email this to me. We'll take it up privately. Okay? If you have anything immediate, Vittorio, press *5 on your phone. If you are here and you have an immediate question that you want me to answer right now or try to answer right now, press *5. Okay. Let's go on to the next one. Mina 2007 said, I have a 797 until 2017 based on client A. I moved to client B, Minnesota to Massachusetts. So Minnesota to Massachusetts. They did not file an amendment for 1 year, only LCA. Now they are going to file LCA and amendment. Yeah, I think we should be okay because remember, USCIS had made some exceptions like a grace period up until January or something. So I think they are likely to forgive this. It should not be a problem. Normally it would have been, but because they have extended, for lack of a better word, like an amnesty, I think you should be okay. So if you have a follow-up question, press *5. Mina, if you are here, you have a follow-up question, press *5. We'll do new questions at the end of this, guys. Okay. Vijay, I'm going to skip that question if it's the same individual posting. Yeah, I'm going to skip that. Amit Garg, I got my first and only H1B stamped in April 2008, which expired on 2011. So the question is, am I exempt from the H1 quota? Well, since you got your visa stamped, Amitji, the law says you are not subject to the quota if your H1 was approved within the last 6 years. Okay. So your H1 was approved in 2008, which is not within the last 6 years. But it was good till 2011, which is within the last 6 years. We had this discussion with USCIS, and they told us that they look at the date that the H1 is expiring to make that calculation. So you should be exempt from the H1 quota. Have your lawyers double check this because USCIS has not put this down in writing anywhere, but they did indicate it to us in a call. Okay, and we've been proceeding on that assumption. If you are here, press *5, Mr. Garg, Amit. If you are here, you have a follow-up question, *5. Go ahead, please, Amitji. Go ahead. I can hear you.
Hello, Rajiv. Can you hear me?
Yes, I can hear you.
Yeah, actually, a lot of employers, when they see my status of visa, they hesitate to take the case further. So I'm not sure what should I tell them.
What I just told you, you can play this part of the recording. And if that satisfies them to at least try, good. If not, there's not much we can do about it, Amitji. Okay?
Okay. So is there any official
Not yet.
website of the
Not-
US government also where
Not
particular
yet.
rule is specified?
Not yet. Nothing has been written down.
Oh,
All right?
okay.
Good,
Okay.
good luck, sir. Sorry, it's too much noise from your side. Can't really hear you that well. Okay, going on to the next one. JHU, H1B was recently extended for 8th year based upon pending Balka appeal. So if the decision is not in my favor, will they take away the H1? No. Once they give you the H1, even if the decision is against you, they do not take away If my company files a new PERM in a different position, will we have to withdraw our BALCA appeal or can we continue it simultaneously? I think it's a little bit complicated. I haven't done this for a while, not been in that situation. A few years ago, 3, 4 years ago, the procedure used to be if there is a PERM pending for an individual with the same name, with the same company, even if it was for a different job, Department of Labor used to deny the second case, and you had to file a motion to reopen and explain why this was a different job. Although that used to be the old process, I was told that that process has changed. Has it really changed? Are they really doing something different? I do not know off the top of my head, and I'm not aware of any written standard operating procedures on this issue. Okay, so if I were your lawyer, I would plan it in such a way that when the second case is filed, I have enough time on my H1 so that even if I have to withdraw the appeal, which I probably would, I will be able to continue your H1 based upon the second filing. It can be done. The timing has to be just perfectly arranged so that the second filing leaves you enough time on your H1 so that when you withdraw the appeal, it doesn't hurt your filing. Okay? If you are here, press star 5. Star 5. Guys, try to be in a quiet place because some of you, when you come on the phone, I can barely hear myself think. So I'm not sure how you are hearing me, but try to find a quiet spot for a minute or two when you're talking with me. Your last question, you're not here, JHU. I'm planning to travel to India in October. Will have to get my visa stamped. Will it be a problem if I have only 9 months pending H1B validity of 9 months and pending bulk appeal? No. Technically, even if you have 10 days pending, 10 days remaining on your H1, you should be able to get an H1 visa stamping. So I don't think that is a problem. All right, since you are not here, I'll go on to the next question. This is Vasai Kart. I have an approved H1B and I-797 from company A. Let's see, I recently started working for company B on H1B receipt. Company A has not yet revoked. Now I have an offer from C, like to join. Well, I've said this before. This is like a domino effect. Okay, so A, B, C. Now you moved over to B using the receipt. You want to file for C. You should, if you are going to keep working for B, technically you can join C when their receipt comes. But in adjudicating the case for company C, government wants to make sure that company B's case was approvable when filed. So even though you've changed over, they can still request information like end client letters, etc., to prove that company B's case was approvable when filed. If you're not able to procure that, and if they are going to approve company C's case, they will ask you to go outside for visa stamp. Okay. So as far as there being any risk in changing companies, that's your prerogative. You can change as many companies as you like in as little time as you like. Okay. Star 5 if you are here. Star 5 if you have a follow-up question. Okay. Now, Chetana has a question of continuous residency. You've been only out one time for 7.5 months. Rest of the times you've been hardly ever absent. And you had a very good reason. There was a cancer diagnosis and treatment, and then she passed on, your mother-in-law. I don't think this should be a problem. I think things like proof of her sickness, hospitalization, bills, maybe doctor's letters, diagnosis, anything that you can procure combined with a letter from you explaining if asked. Remember, um, they don't always ask for you to explain, especially with your kind of background. So you can certainly, I think you'll be able to prove quite easily. Okay. Then what are the current processing times? That depends upon where you are filing. Again, I bring you to the page on our website which talks about processing times. And if you look at the right side, national processing times, it actually tells you how to check what the processing times are, where they are. So you look for N400. So if we look at, let's see, USCI Service Center processing times. If you go to this page, it will bring you to where you need to go to check the processing times. And how you get to this page is you just scroll down to the footer on our website. Under common topics, there is processing times and status checks. Okay, so typically USCIS has an aim of reducing all applications processing times to less than 6 months. Okay, but it depends upon where you are filing from. If you are here, press star 5. Star 5 if you have any follow-up questions. Okay, once I finish this round of questions, we'll start new ones. Oh, you are here. Okay, let me unmute you. Go ahead, please. I can hear you, ma'am.
Hello, Mr. Khanna. This is Chetna. Thank you so much for the detailed explanation.
Of course.
So do you advise not providing the supporting documentation from doctors and other documents unless asked?
Of course not. Of course not. Do not provide unless they ask you. I don't remember if the N400 says you have to provide it up front. I'm quite sure it does not say so. I'm quite sure that you can just file the application. Bottom line, Chetna ji, is follow the instructions on the N400. Okay.
Okay.
From what I recall, we only supply the information if they ask for it, and they don't always ask for it.
Okay.
Okay.
Because we were concerned since it's more than 6 months, but,
No, but
so we don't provide any lease agreements, any rental payments, nothing until unless it comes to their attention and they ask us.
Not at the moment. One key issue that they can raise is, by the way, Chetaji, are you currently working outside the house or are you a housewife?
We are both self-employed, so we have a startup company.
Okay.
So my husband and I are both owners of that company.
Okay, so sort of like the past of Microsoft. In a few years, you'll be taking over the world, huh?
Hopefully on the finance side.
So, well, my question, one of the concerns that the government raises in these applications is, did you guys start doing a job in India? So if you were in India and you took up a job, then they look at the case suspiciously. But even then, if you have such a good reason, you're not there for the pleasure, you're there because of a family necessity. I think you'll be okay. I don't see any
Yeah, we haven't worked outside the country. We've only worked here since the late 1990s. So there's no employment outside this country.
That makes it a very strong case for you not to have any issues. Go for it, you'll be fine.
Awesome. Related to this, the second question, processing time, is it okay to travel outside the country while the citizenship application is in process without having to amend the original application?
Definitely okay, but your trip should be less than 6 months, and they will certainly ask you about trips. When you go for the interview, they ask you, have you been outside since filing this application? And if you have been, and if it's less than 6 months, it's no problem.
So you don't have to amend the application saying which dates you've been out again.
No, ma'am.
Awesome.
No, ma'am.
Thank you so much. We really appreciate your help for this. It brings a lot of clarity for us.
You're very welcome, and good luck, ma'am.
Thank you. Thank you.
Bye-bye. Okay, so let's go on to the next question, which is SG22. currently on H1B with approved I-140, more than 9 years in this country. Priority date is December 2010 EB2. Any news progress on the executive order? Nothing so far. I told people in the last conference call, I think, or was it on the radio show, that there was a regulation on the agenda, regulatory agenda this year, but this year is ending at the end of this month. October 1st, the new year will start. So I'll post something if I see on the regulatory agenda if they have renewed their desire, USCIS's desire to issue a regulation. So right now we don't know. Second, if I change employer, current employer revokes I-140, would my wife be eligible for H4 EAD? No, because USCIS has made this clear. What they've said is, in order for us to give you an H4 EAD, there must be an I-140 alive and well. If the I-140 is gone, we will not issue you the H4 EAD. No longer how long you've lived here, no matter how long you've lived here. Okay, so once she gets her H4 EAD and you change employers, I don't think that should affect her even if the I-140 is revoked, because USCIS said, look, we reserve the right to revoke H4 EAD if the I-140 is revoked. I don't think they are going to do it. I doubt very much. I don't think they can keep track of these things. We can't predict, unfortunately, the movements in EB2. And EB1 category is only available for people who are considered to be very top of their professions, nationally or internationally. So really, I don't have much information to give you, sir. If you are on the phone, press *5, *5. Okay, okay. Maybe I'll call for *5 before I ask the question. All right, all right. This one is okay. They are here. Let's see. Yes, sir. Go ahead, please.
Hello, Rajiv. So I was listening then, but there was a little bit of a disturbance here or problem on my side. So I just want to confirm. So what we basically said is number one, on the H4 part, irrespective, if I change jobs now, if I-140 is revoked, then automatically my wife's H4 EAD would also be invalid.
No. That's not what I said. Let me repeat it. Okay. What I said is, number one, for her to get an H4 EAD, at the time her H4 EAD is approved, you must have an I-140 alive and well.
Okay.
Second, if after the H4 EAD is issued, you change jobs and the I-140 is revoked, USCIS has said, we reserve the right to revoke the H4 EAD. They have not said that they will automatically do so. I personally think they won't do it. They will not do it. That's my my guess. Okay.
Okay. All right. And I think what I just other thing I heard is that that the I-140 rule where I-140 people can apply for the EAD, the 485. That is what you said is still nowhere near getting done, right?
No, you know what I was hoping. What I was hoping for was that because it is on regulatory agenda of this year. Okay, so I was hoping that by September 30th, which is the end of this month, they will publish a proposed rule. But so far nothing. And if they are going to do it this year, government fiscal year ends on September 30th and begins again on October 1st. So if they don't do it by September 30th, I will look at the next year's regulatory agenda and let you guys know where we stand with that rule. It doesn't tell us when they are going to promulgate the rule, but it does tell us if they are serious about the rule or not. Okay?
Okay. And Rajiv, one sort of other question, a little related but not exactly related with my other list of questions.
All right.
So I am on H1B, but on that vendor, I have like a vendor cop to cop arrangement where I work on a client side, but through a vendor basically. So my extension is coming due in December. So I have so in that situation, I'm hearing that H1 extensions are now very very more difficult. Is it true that they need a client letter with and they give the extension only for a number of months, written on the client letter or on the vendor letter? Because no client gives the the paperwork for 3 years in total. They will give 5 months, 6 months extensions at one time. So does it mean that for every 6 months you will keep filing extensions now, or how does it work there?
You have two questions here. One is a client letter necessary? And the answer is yes, unless there is enough other evidence like job order or work order or what they call PO, performance order. There are all kinds of different names
Okay.
used. If that particular work order has all the details the government wants to see, then the client letter may not be necessary. Or a combination of this and other documentation, including a contract between the prime vendor and the end client. So something will be needed, otherwise, approval of the extension becomes uncertain. Number one. Number two, will you be given H1 coextensive with the work order? And the answer is probably yes. Okay, we have been able to successfully get approvals beyond the work order in some cases, but it's by no means guaranteed and becomes quite difficult. So difficult to say, but that's where you stand. Okay.
Okay. Another thing there,
I have to,
one of my friends
sir,
that
sir,
15 jobs.
I'm sorry, I have to cut you short. I can't spend that much time. Got a bunch of people waiting. Make it no more than 10 seconds, and I'll be able to answer your question. Go ahead, please, sir.
Sure. Yeah. So if my client changes again after a few months, and while my extension, do we need to file for extension again if my client changes just because I'm a cop to cop arrangement?
In my view, absolutely, no question about it. Okay. Good luck. All right, sorry guys, you gotta be a little bit mindful. We got a bunch of people waiting. I would like to spend more time, but it is our time is rather limited at this, so it's a good idea to cut short your questions to as little amount that we can, take. So, Sunil R. Kimi, concurrent filing along with priority date porting. I have an approved I-140 from employer A, EB3. If I switch jobs, employer B did EB2. EB2 date was current, so employer B did I-140 recapture and 485 concurrent. Well, once your I-485 has been pending 180 days, you should not worry about losing priority date as long as your jobs are same or similar. So it is true that a priority date would be lost if the I-140 is revoked by the old employer. That's the USCIS thinking these days. But if you are protected by AC-21, which is I-140 approved, 485 pending 180 days, job is same or similar to what the green card job was, in that case, even if the I-140 is revoked, it should not take away your priority date. Okay. Now the question is, this is a tough one to answer. Can you stay in EB2 category? Because what you are trying to do is you're not using AC-21 only. You are using AC-21 along with a new green card under EB2 category. Okay. So I think it's a tough question to answer off the top of my head. I don't think USCIS has ever addressed this issue. I would argue that yes, you are entitled to AC-21 as well as to keeping your EB2 category date. But it's a toss of a coin. I don't think, Sunilji, that anybody can give you a definitive answer on this. Okay. And just because you have an I-45 receipt notice, and if the I-140 even has the old EB3 priority date, does not secure it. It does not. Okay, even if you get the approval copy of the I-140, it does not secure your priority date. It can still be taken away. What secures your priority date is AC21, and what makes it uncertain in your case is because not only do you want to take AC21 to protect your priority date, you want to then carry it a step further and move it to your EB2. Not sure you can do it, don't know. If you are here, *5, Sunilji. *5. Okay. Next question is again Sunil. I don't know what this question is all about. Guys, try to make it all in one, and because I have these scattered questions, don't do that. I'll start skipping them if you put them in separate questions. So EB3 is approved. New employer has filed for EB2. It was approved. No change in the LUD. Well, none of this is really relevant. These are all procedures. The basic law that the government is following is, if your I-140 is revoked, your priority date is gone. Even if they have given you a new approval notice, it does not secure it. Only AC21 secures it. Okay. And Dhruv Dayal Gupta is a researcher, wants to migrate to USA. Dhruvji, are you on the phone? Press *5 if you are on the phone. *5. Okay. *5 if you're here. You're not here. I actually want to do a separate call with you. Good, you are here. No, this is the same individual whom I told to keep your calls to the very end. I'm not talking with you right now. I'm talking with Dhruv Dayal Gupta. What I want you to do, Guptaji, is send me an email to help@immigration.com. Let us do a Skype call and make a recording. It will help people in your situation all over the world. So we can have a more detailed recording, if that's okay with you. We can go over all the options that any professional from anywhere could possibly have, or a businessman could have, in kind of a more comprehensive format. I think I'll need about a half hour with you. Okay. So if you want to do that, send me an email. We'll set up a call with you, probably one of these Fridays, and go over it. Okay. And this is the last posted question. Then we'll start the new questions. Also, Saikar, again, please don't post your questions in separate places. I don't like that. It just makes it more difficult for people to post, because they, like I said, they cut off at between 20 and 25 questions. So if you post a bunch of questions, it takes away from other people who can. I'll do it this time, but in future, if you post multiple questions, I'll start ignoring the subsequent ones. If one has an I-140 approved and the I-140 is not revoked, it's never revoked. If the person changes job based upon his approved I-140 a few times to several different companies, and if an H1B gets denied for one of the subsequent companies, can another company, totally new company, file an extension of transfer based upon the original approved I-140? Yes. You see, you can have an approval based upon the old approved I-140 for any company. So that's not a problem. If some other company in that chain starts to file PERM and the PERM gets denied, can candidate move to another company and restart the process based upon the original I-140? The answer is yes, definitely. And about Obama executive action, we don't know. Okay, so let's start with the new questions, folks. Anybody who has any question, press *5. Anybody who has any question, press *5. And I will take your questions in the order that you called in to the conference call. So far, I have only 4 raised hands, 5 now, 6 now. Please make sure anybody who has a question, raise your hands, because at the end of this 6 calls, I won't do any more. 6 it is then. I won't do any more. We'll only do these 6. Okay? Guys, I get tired. It's a lot of talking for one man. So let's start with, again, I'm going in the order that you guys called in. Okay? Oh, this is Chetna ji. Chetna ji, go ahead, please. Yeah, Chetna ji, did you have a phone? Yeah.
Hi, so I think hearing the sound of my voice. I don't know if you can hear the resound, otherwise I can go ahead with the question.
No, go ahead. It's okay. Ask your question. I'll answer.
So let's say the situation is this. I've just obtained my US citizenship and I would like to travel to India. Do I need the OCI card before I can travel, or there's a grace period during which I'm allowed to travel to India because I'm no longer an exclusive Indian citizen?
I do not know the answer to that question. Unfortunately, I practice only on the US side. Last time I practiced in India was in 1986. Okay? No idea.
Okay, no problem. Thank you.
Good luck, ma'am. All right, 5 more people. Let's go to Indiana. Indiana, go ahead, please. Indiana, your phone number is area code 219671. I can hear you. You are unmuted.
Hi, Rajiv, sir. This is Nishant. Sir, I sent you an email regarding.
Oh, yeah. I told you to call into the conference call. Nishantji, remind me of what's going on with you.
So basically, I've been laid off, and the situation is that I will be laid off on the last day with my company present employer is on 8th, and I have a new employer who's offered me for a new place. Shall I just go ahead with the new employer? The reason is that they will try the filing of H1 transfer in say a week's time or probably 2 weeks' time. So can I wait till then, or should I have to move with somebody just to avoid the out of status?
So your question can be generically reduced to the issue whether or not. Look, guys, don't raise new hands. I see a couple of hands raised again. I told you in the beginning, please raise your hand if you have a question now, because I'm kind of husbanding my energy. Don't raise hands, please. I won't do any new questions. Okay, only the first original 6, now 5. All right, so going back to what you were saying, your question really is this, Nishantji, that is there a grace period between the time I stop working for an old employer and the time a new H1 application is or a transfer application is filed by an employer? And the answer is there is no grace period. That's one of the complications of an H1, that if you lose a job and you stop working, you are out of status immediately. Okay. Now, if there is a time period, let's rephrase that. If there's a good explanation for it, for example, if you are laid off unexpectedly and you worked as quickly as possible to get another petition in place, you can ask USCIS to forgive that out of status period. They may or may not. Worst case scenario, they will ask you to go outside USA for visa stamping before you can start working. Okay. Now, if the time period between the two statuses is rather large, you can try to bridge it with something like an application for a tourist visa. But here, there is only a matter of days. Is that correct? The difference is only.
Yes,
so I don't think you can really cover it up that effectively. You can discuss it with your lawyers, ask them how they feel about an interim application for tourist visa. I probably would have you file it and point to the government that I try to maintain status the best of my ability, but they can treat that application as a non-entity, because until that application is decided in your favor, it really does not do much to maintain status. But it is definitely better than being out of status. So if I were you, in discussion with your H1 lawyers, I would file an application for a tourist visa requesting 15 days or 20 days, whatever time you need. Okay, that's what I would do.
Okay.
Okay.
No.
Good luck to you, sir.
Thanks, sir.
Oh, you're welcome.
Thanks.
You're welcome. Okay. I got more raised hands. Guys, put them down, please. Okay. Well, I've got 5 more now. I will do 5 more. There were 2 more. Thank you. I appreciate it. You put your hands down. We'll take it again. In 2 weeks, we are talking again. If it is very, very urgent, leave it up. But if it can wait 2 more weeks, we'll talk again in a couple of weeks. All right. Let's go to Texas. Texas, go ahead, please. Texas. Texas.
Yes. Hi, Rajiv. How are you?
Good, sir.
So I had a question for you, Rajiv. Thanks for taking the question. So the situation is that, giving you a background, I'm currently on an EAD. My previous employer, my first employer, had filed for the green card. We got lucky in the concurrent I-140 and 485 in 2007. Since then, I'm on an EAD. I've moved a couple of jobs since then, and my employer still kept the green card process, which is an EP3. With my current employer, I requested them to start a new process in EP2 since I acquired a couple of masters since then. I'm currently planning on moving to a different company. I've spoken to this existing employer who's willing to keep my green card process live. I had 2 questions, or it's the same question. Can the company still keep the green card process? Where I am with this company is that they've initiated the residency case, and they've gone through the advertising and interview and are ready to apply for the PERM. They haven't yet applied. They have all the information to apply for the PERM. The company is willing to continue the process. Question 1, if I leave, can they still continue the process for a future employment date? And second question is, what would the company need to keep this process active?
Okay, only thing they can indeed continue the process, and the only thing that they need to keep is the intention to offer the job to you sometime in the future, before or a reasonable period after the approval of your green card. So the process is based upon a good faith intention of the employee to join and the employer to offer the job sometime in the future. So yes, they can definitely go forward.
Okay, wonderful. Thank you so much, Rajiv.
You're welcome. You're welcome. Good luck. Okay, let's go on to the 4th last call. This is Pennsylvania. Pennsylvania, go ahead, please.
Hi, Rajiv. Good afternoon. This is a follow-up question for the number 14, Mina 2007.
Okay, give me 1 second. Let me get to that question so I can refresh my memory. 14. I remember the name, but I don't remember the question. 1 second.
14, Mina 2007.
They haven't filed amendment for 1 year, right? H1B amendment?
Yes.
Okay, go ahead,
Right.
please. Yes, go ahead with your follow-up.
I have not put this question, but I have a question.
That's okay.
You said that if employer doesn't file for 1 past year, is it not a problem, correct?
Yes, because what the government said was that they are going to give us kind of an amnesty to amend applications, and I think it was till, don't quote me on this, but I think it was till October or September, but then they extended it to January, I think. So your employer can double check that, but I think you should be okay.
What happens if this candidate goes to visa, for example, to India or somewhere, and if the visa entry officer is asking the same question, and if there is a chance for him to ask, can you show the previous, amendment? There is a chance. Do you think that?
No, I don't think that would be a problem. The fact that an amendment was not filed for a year is not likely to be a problem for visa denial. I would be very surprised if that happens.
Okay, because one of my friends recently went to India and looks like the officer asked for all the previous H1s and luckily he had it and he has no problem. So
Well,
that's why.
they can ask what they want, but they should not base a denial upon a prior failure to amend when the most current H1B is perfectly um, legal in all other ways. So the past should not affect the present.
Okay, I understand. Thank you very much,
Oh,
Rajiv.
you're welcome. Good luck, sir. Okay, let's go to the third last question. And this one is from Illinois. Illinois, go ahead, please.
Hi, Kannadi, this is Deepshika here. We were conversing earlier about a year ago, so just to rehash, I have a PhD and I have about 5 years research experience, about 3 years teaching experience, or rather 4 years, and now in a tenure track assistant associate professor position. What category do you think would be best for
I remember you. I remember you. We also
How are you
exchanged
doing?
very, very good. How are you? So good to hear from
Uh,
you. You've got a tenure track
well done.
position. Look, this is what I think you should do, Deepshika ji. Um, you see, there is bread and there is butter. I like both. I think we should have both. So remember, the university can very easily file a PERM case for you under EB2.
Yeah, they're doing that.
Right. So that is my bread. That means if everything else fails, I've got my EB2 case, and if I file it under special handling, because I'm filing this case within 18 months of joining. Excuse me, they're
So
paging.
is it 18 months of joining or 18 months of the advertisement?
Actually, 18 months of the selection, not even advertisement.
Okay, 18
It's
months.
I think the law says 18 months of the selection. So when the final, I believe, I mean, I don't remember off the top of my head, fine nuances, but it is either the selection or the date of joining. I think it's the selection. Okay.
Yeah, okay.
So then we've got the bread covered. Now, in addition, you must, absolutely must, try EB1, outstanding researcher professor, because if you win under that category, your green card is wrapped up within a few months.
Okay, because the cases are current.
Right. And not only that, because EB1 A and B you can file in the premium process.
Right.
Okay.
Okay.
So go ahead and do that also.
So can I contact you for that later on? Separate?
Double check with the university, ma'am. If the university allows you to hire outside counsel, great. We'll be happy to assist you. But if the
For the card processing, I think they'll do it on their own. They have a lawyer here.
right, because this too is an application filed by the university. Okay. If the university, some universities will tell you if your lawyers want to work with us, they have to qualify. That's not a problem. Normally, most universities only require a letter from the bar saying we are members in good standing of the bar. If they want us to do that, no problem at all. But many universities, for whatever reason, have a relationship with one or two law firms that they work with. Okay.
Yeah, so I'll ask them if
Please
they would
do.
allow you.
Absolutely. Absolutely. And good luck. Congratulations.
Thank you very much. Thank you very much for answering my question.
My pleasure. Good luck, man. Okay. And now we come to the second last question, which is my own neighborhood, Virginia. Go ahead, please, Virginia.
Yes, hi, sir. I have a question for my friends. We just noticed is we have another the thing is called EB3, and she's F1 student right now in the United States.
Okay.
And how can she apply for that?
Oh, okay, ma'am. This is a very large and long question. Okay. Basically, the way most students do things is this. First, they finish their degree, and then okay, and then they apply for usually for something called OPT, optional practical training, which gives them permission to work for 1 year. During that 1 year, sometimes they start their green card process with the employer. This is something the employer does. Okay, so the EB3 or EB2 is something the employer does. EB3 simply means employment based category 3. EB2 means employment based category 2. Okay, so what they do is usually finish the degree, then do OPT. During OPT, start green card or wait till you get your H1. So F1, OPT, H1, green card. That's the normal method. Okay.
Okay. Your office do this, right? Do your office do this?
Yes, ma'am. We don't find employers, but if you have an employer who wants to do all this process, we'll be happy to guide them through it and take care of it for you.
Oh, so we have to find an employer for that.
You need an employer, not a lawyer, an employer.
Employer, yes.
Right.
So what is like I know some of my friends have told me before is like she gets through like a restaurants and stuff. So what is the qualifying?
No. What you need is, for the route that I am considering, what you need is a job in your friend's own field of specialization. So if your friend is a chemistry major, he needs to find a job in chemistry. Okay.
Okay.
So you can't just go to a restaurant and get a job there. That is a totally different set of things. It's not, you can't get an H1 for those jobs usually. Okay. So, and you can't even do optional practical training for jobs that are not related to your degree. So no, she will need or he will need a job in their own field. Okay.
Yeah, she has to find a
Right.
in her field, right?
Correct. Absolutely. Okay.
Yeah, but that's the problem she has. Can't find a job in her field who
there's not,
run field.
we can't do anything until they have a job in their field, unfortunately.
Thank you so much. Bye bye.
You're welcome. Bye bye. And now the last question for the day, folks. Go ahead, please. Go ahead. Hello.
Good afternoon, sir. My name is Anand.
Yes, sir. How are you, Anand?
Can you hear me, sir?
I can hear you perfectly.
Thank you for taking the call in spite of the late time.
My pleasure.
I have currently I'm working for an employer and they filed an EB2 and it got approved in 2009. And then they filed an I-140 and then it got approved in 2011. And fortunately for us, our dates became current sometime in 2012 and we've been able to secure an I-485 for me and my wife.
Good.
So we have an EAD and we've been able to renew it and keep it alive. Recently in February we had an NOR on the I-140.
Oops, that's
Is it revoked yet?
Okay.
Sorry.
No, that's usually a bad sign. Okay, so then.
Yeah, so we were sent a response to it, and we've been waiting for the reaffirmation. But in the meantime, the client I'm working for has given me an offer, and I just wanted to find out if I can use AC21 to join and keep the priority date.
It's risky because if the I-140 gets revoked, everything is out the window. Okay, because if the I-140 gets revoked, the 485 gets revoked.
Right.
Okay. So,
but
hang on. Let me tell you what I think you should do.
Sure.
First question is your employer okay with you joining the client? They have no problem?
I haven't talked to them yet, but I just want to make sure that the AC21 option is available for me.
AC21 is not going to work unless the I-140 is allowed to stand. If the I-140 is revoked, there's no AC21.
Okay, so the employer has to continue holding the I-140.
What I was thinking was this,
Okay.
And you can listen to the conference call recording later. Yours is the last call, easy to remember. This is the strategy that I would follow for my own clients, for our own firm's clients. I would, if the old employer is willing to fight out the case, and they're okay with you transferring for now, because you can always go back to that employer if they so want. So I would have you file an H1 with the new employer and get that H1 stamping done. You've got your maybe even 3 years H1 because it's not yet revoked, at least 1 year H1. If the I-140 is revoked, file an appeal against the revocation through the old employer. And while the appeal is pending, you can keep getting H1 extensions. In the meantime, as soon as you join the new employer or even before that, you start a green card through that employer as well. That way you are protected for further H1 extensions.
Okay.
Okay?
That'll give me the option to continue with the new employer.
That's the way
keep extending H1.
That's the way I would do it. Yes, sir. Okay?
Okay. But it all depends on the the current employer.
Yeah, because if they don't, if they are not going
alive.
to, if they are not going to fight out the I-140, then your options are very limited.
They did respond to the NOIR. We haven't received any yes or no yet from the USAR.
Yeah, but if it gets denied, then we would want them to file an appeal too, because that's what would also protect you. While the appeal is pending, you can keep getting H1 extensions.
Okay.
All right?
All right.
Good luck, sir.
I had one more question, sir. About the I-140, I have an approved H1 on that till 2016, so that's not going to be affected by
no,
result either way.
Not normally, unless they are really ticked off with the employer and there's fraud involved, and they want to go in and revoke all the H1s that they've given. I have never seen them go back and revoke H1s. I've seen the situation many times.
Do you know what the timelines are for response to the noise, sir?
I do not. That varies widely.
Okay.
All right.
Is it in months or years?
Months, not years. Definitely not years. Weeks or months.
Okay.
Okay.
All right.
Good luck.
Thank you so much.
You're welcome.
Thank you.
Bye-bye. Folks, as always, it is great talking to all of you. In 2 weeks, which is September 17th, we'll be back again. I look forward to hearing from you and talking with you again. Thank you.
Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.